Right, 1, 2, 3, 4. There we go. You just turn on lights. All right, so I had court today, and it seems like the main theme was to decide on whether or not I get to take the evidence, this new video evidence that was recorded on the 27th of January, 5 days after I was arrested. This new evidence held since January 27th, February 27th, almost 2 months. This prosecutor held on to this evidence and then waited until 2 days before my trial before presenting it, and made the arguments today in this spontaneous hearing. I got notified 3 days in advance. He said in this hearing it was actually 4 days in advance, but I didn't get any paperwork until Friday, and he said it was issued on Thursday. Did they sit on it a day? But either way, a day compared to this video evidence being recorded way back on January 27th and 28th is a big difference in time. So the big theme was whether or not I could take this evidence out with me and share it with the public or just use it at my own leisure. I had to write everything. It was two librarians talking, giving a verbal testimony with 2 different cops, giving testimony about my arrest, what led up to it. I would mostly wrote down what led up to my arrest, and I spent about 2 hours after this hearing. I spent about 2 hours listening, so that took up a lot of time, but I don't want to show the name, but yeah, it shouldn't show the name, right? So it's all pages and pages. I made sure to get every word that he said and she said, because it's interesting for one, and it could be important for 2. But at this hearing, it was a lot of arguments about preventing me from taking this testimony that was recorded January 27th out of the courthouse and also further, the prosecutor Cloyd Benjamin was arguing that he might be filing some felony charge against me for witness intimidation. This librarian who I cannot name, because apparently even naming the person is considered an offense in Louisiana. At least that's what Judge Owsley is saying. He's saying, oh, because he's elected, it's okay to talk about him. But if you're not elected, but you work in government still, you can't even be named. These people are going so far to the extreme with like this protection policy. It's not enough just to withhold the policies for the public employees. No, just mentioning their names, depending on the circumstances. I guess if you label them a witness and then mention their name, you can get charged with a felony. It's really gone so far to the extreme about this protection. I tried to make my best arguments. I tried to say YouTube polices the documents, because I with these exhibits I saw that there's some a couple of my videos he was referring to, so I pulled those down. But they kept arguing that just the name is enough. Like, you could just search this name and you're gonna find out everything about him online. I told them, I repeated myself. I wasn't speaking clearly enough, I guess, because I was ruled against. I lost today, pretty much. Just, it was a hearing. It wasn't a hearing to put me in jail. It was just to prevent me from taking this this witness testimony out of the courthouse. In-camera inspection. But I kept trying to tell him there's no birth date, there's no address, there's no phone number, there's no picture of this person. Just a name isn't gonna identify him. And he's like, ultimately we got to this point where Judge Owsley was like, well, I could look their name up if you he just wanted to establish, that's all he wanted to establish. Did you give a name? And I'm like, sure, yes, there's a name, and well, I could look them up on the internet. You can look their name up on the internet. There could be somebody else with the same name. I didn't say that. I wish I did. I didn't think of that. But I was sticking to, there's no birth date, there's no address, phone number, picture. I also could have said there could be other people with the same name. But ultimately, he said, well, I can look them up. And I was like, these people, the people make themselves as available as they want to be available on the internet. And well, he had to pause, but then the prosecutor had to butt in. The prosecutor saved him. If he would have stayed quiet and let Judge Owsley ponder that and work up a thought, I would have been interested to hear that. But instead, the prosecutor kind of saved him, and it was on purpose, because that's what they do. He butted in once again, adding that he might be filing a felony charge against me for harassing the witnesses. And Judge Owsley recognized, it made it clear that that's not a part of this city court. It's above their pay grade, above their jurisdiction. We're talking about filing, Clyde Benjamin filing this in more of a district court. It's to be separate charges. We go through the whole process again, intimidating a witness, and he's got a crying witness too. But she cried on January 28th, way back in January 28th, about getting contacted. She cried in front of the cop, and the cop, wow, he was just like a troll on YouTube. Oh, I think Travis goes around and does this stuff on purpose, trying to elicit a response, and he's got what's coming to him, and all of this. This cop was totally on board, comforting her while she was crying, and saying that I do this on purpose. I go around the state to state and intimidate people and get them to call the cops on me. So if you get the cops called on you, that's a standard. That's like, if they don't say that, you wonder what's wrong with them. If they don't accuse you of causing them to call the cops on you, if they don't accuse you of that, there's something wrong. That's a standard cop statement to make, to blame you for the cops being called on you. It's just such a standard statement to make when you're not doing anything wrong. So this hearing was, I lost it, and so my punishment was having to sit in the courthouse listening to listen to their testimony, 2 testimonies, and I wrote them down, a male and a female. The male is a new one. He didn't write a statement. He was kind of a part of it. He didn't call, but he was there with the caller. And he's got some interesting thoughts about this. Let's see what we can find here. I think I'll just make a separate video on his statement. But I copied verbatim everything he said up until the arrest, and then I just listened after that. There's really nothing to write after the arrest, because it's all on camera pretty much. I didn't acknowledge the DVD section.
I'll go ahead and take video or pictures of it the way it's laying right now. Just verify if we can do that.
So this park outside or something. They said they both said that I was slamming something. There was some kind of a knocking noise. Yeehaw! We got a. There was a report there's supposed to be a flooding of the river today. I saw that on the weather app on my tablet. But this is what it came down to. Today's hearing was whether I could bring the evidence with me or I have to leave it in there and write notes about it. And I lost because Judge argued that I used her name. I couldn't be trusted with these statements. I might broadcast them and embarrass them. So he was taking the precautious choice. He'd made the precautious choice of not letting me bring this testimony. But for the prosecutor to bring it forth 2 days before my trial, that is a dirty move. And the judge asked, is there going to be any other surprise evidence? All right. I don't know the exact wording, but I do recall him asking the prosecutor, and it sounds like Prosecutor Benjamin doesn't have anything to surprise us with. But to hold something from the January 28th is quite amazing. So on Wednesday, I still have Judge did not want to do the hearing on suppression of evidence. He's just going to deny it eventually. He's just holding off on it. So we're keeping the Wednesday hearing for suppression of evidence, and then also the city's motion to the motion for the protection order against me, which, you know, I got this, for some reason they gave me some of the police. I got Jordan Davis and La Quintas, and then also, oh, that's out of the packets, and then some awards. This is for Miller, right? Miller's got the thickest packets. So we got an award for Thurman Miller for graduating the academy in 2019. He knows how to prevent sexual harassment. I mean, wow. Each certificate? Come on, guys. Why'd you have to bury me in paperwork like this? I'm already stuffed enough, and they bury me with 3 packets, each individual certificate. They couldn't just give me a list of their certificates, like these are their certificates. I have to be given a photocopy, emergency firearm response, police traffic safety and crash reporting, police department defensive tactics, preventing sexual harassment. Again, he needed extra training, firearms training and transition course, criminal code update, de-escalation on 3/25/2021. Thurman Miller got de-escalation training. I think they just kind of signed him on through that. He slept through that, and they just gave him a certificate. He doesn't know anything about de-escalation training, so that's something to hold on to. Look at that. He's got de-escalation training. Thurman Miller. I gotta get a picture of that. Thurman Miller's de-escalation training, huh? Real good. Who teaches this? State of Louisiana Peace Officer Standard and Training Council. So who's the person to really blame? Gang-related sex trafficking and sexual assault, preventing sexual harassment. And then these are interesting to me. There's 4 of these recent. responding to sexual assault, investigating sexual assault, gang-related sex trafficking, preventing sexual harassment. A lot of sexual stuff might be a big problem down here, but well, let me just say, I find La Quinta Favors to be pretty interesting, actually. I'm not familiar with this. What's the Monondoc expandable baton? Monadnock expandable baton. So she's got that training. Successfully completed the course requirements for the AirCo International Chemical Weapons User course. She's got very little because she's more like she's more like a part-time worker. Taser training, firearms, 140 hours of law enforcement training. So it's interesting. I really don't appreciate being buried in paperwork like this, but I asked for it. I think that out of all these training things, I should try to find Jordan Davis's de-escalation training. Is this the most recent then? De-escalation for Thurman Miller, 325 last year, 2021. Do they have to do this yearly or what? But yeah, I gotta prepare for Wednesday's hearing now. Hearing number 4 coming up.